Hello, good morning students. Please subscribe the channel, drop a like, share and comment. This is Shree Vishnu Art Press Publications exercise number 7 and 8 on the speed of 90 words per minute. Start. Learned counsel for the appellant has placed reliance upon the division bench judgment of this court passed in the case of Vivek Yadav versus State of UP and others 2010 7 ADJ 1, referring to the UP recruitment of dependents of government servants dying in harness rules 1974 Rule 5. This court has held that, taking into consideration that the mother of appellant was illiterate, appellant was minor though the elder son and there were elder sisters. The proviso to Rule 5 provides that it must normally be exercised as for the purpose of dealing with the cases in a just and equitable manner. Looking into the facts of the case, the division bench held that the appellant had made out a case for invocation of the power is vested in the authority to waive the time for moving the application. The impugned order of the single judge was set aside and relaxation was given. Per contra, learned counsel appearing for the respondent referring to a full bench judgment of this court in the case of Shiv Kumar Dubey versus State of UP and others reported in AIR 2015 Allahabad 47, wherein certain guidelines have been laid down by this court and any relaxation cannot be granted or extended. It is also to contend that the provisions for grant of compassionate appointment do not constitute a reservation of a post in favor of a member of the family of the deceased employee. Hence, there is no general right which can be asserted to the effect that a member of the family who was a minor at the time of death would be entitled to claim compassionate appointment after attaining majority. Accordingly, the learned counsel for the respondent sought to contend that no error was committed by the learned single judge in rejecting the application for compassionate appointment. Having heard learned counsel for the respective parties and also having noted the judgment of the Honorable Apex Court in the case of Vijaya Ukarda Athor versus State of Maharashtra reported in 2015 3 SCC 399, wherein law has been laid down with respect to need for proper consideration of facts and applicable norms, including changed norms. In para 11 of the said judgment, the Honorable Apex Court has noted that the appellant is the daughter through the first wife and respondent number 3 is the son through the second wife of the deceased, who died on 18/6/1997. Appellant's mother submitted application on 29/12/1997 stating that her daughter, that is appellant, who is aged 17 years and then a minor studying in 10th standard should be given compassionate appointment when she attains majority. According to the appellant, after she attained majority, she has submitted another application dated 19/3/1998 seeking compassionate appointment. Thereafter, the appellant was married in the year 2009. This factual situation of the matter was considered and the matter was remitted back to be considered afresh. The fact in the said ruling provide therein that till the age of attaining majority by the minor dependent, the time is relaxed to submit an application. Learned counsel for the opposite party, number 2, has further submitted that admittedly the revisionist has not produced the high school certificate as required by Rule 12. The document on which the revisionist is relying is a photostat copy of the high school mark sheet in which the date of birth of the revisionist is mentioned. However, it is not disputed that the original mark sheet was also filed by the revisionist at the appellate stage. The submission on behalf of the opposite party, number 2, is that the high school mark sheet cannot be equated with matriculation certificate. When Rule 12 requires that there should be matriculation certificate, then any other document cannot be substituted in its place. The mark sheet is a document which states the marks obtained by a candidate in different subjects. It is not a certificate certifying any fact. According to him, in the absence of a high school certificate, the board and the first appellate court rightly relied upon the date of birth certificate issued from the school first attended, in which the date of birth of the revisionist is mentioned as 14/3/1987. The occurrence is of the date 2/5/2005, and as such the revisionist was above 18 years of age at the time of occurrence, and both the courts below have therefore rightly declined him to declare as a juvenile. It has also been submitted on behalf of the opposite party, number 2, that the subsequent criminal case in which the revisionist was declared a juvenile and the order became final was in fact a manipulated case. The FIR of that case was knowingly got lodged against the revisionist, in which revisionist made appearance, and on his application the board declared him juvenile. Since the case was manipulated one, therefore the complainant did not file any appeal against the order declaring him juvenile, and the order became final. But the said order will not help the revisionist in the present case, because the board, under the directions of the appellate court, conducted inquiry and recorded a finding that the revisionist was not juvenile. Learned counsel for the opposite party, number 2, submits that this matter relates to a case in which a minor girl, while returning home with her younger brother, was forcibly picked up by the revisionist and others co-accused persons and was subjected to brutal gang rape by 6 persons. The accused persons not only subjected her to cruelty and brutality, but also her body was burnt with cigarette and lighter. After the aforesaid assault, the girl was thrown on the road. The complainant lodged the report of this occurrence with police station Ashiana, and the police, after a detailed investigation, submitted charge sheet against 6 persons including the revisionist. The co-accused have already been convicted after full trial and have been sentenced to undergo 10 years rigorous imprisonment. One accused was sentenced to life imprisonment. However, two of them were declared juvenile, but they have also been convicted as provided under the Juvenile Justice Act.